Hi, this is Jim Trouts, and I am here with Karen Daly from Ekko Title, and we'd like to talk about a couple of things that are going on with contracts that we're seeing these days. You and I have both talked about some things that are going on. There's two sides to every story, and you've run across a couple of things recently. Why don't you tell us about a couple of things that are going on?
So what I've been seeing, I label them into a couple of categories, right? So we have what we call material or significant breaches, and then we have immaterial, so that's IM material, breaches or smaller breaches, and the contract. So everybody seems to go, it's breach, can I sue, right? And I say, whoa, let's take a step back, let's think about this. Let's look at what type of breach it is first, okay? So if it is a smaller breach in material, for example, not allowing access for your contractors or your inspectors to come in to look at the house, right? The seller says, nope, can't do that. On the flip side, the buyer maybe not getting his insurance, right? You have 7 days to apply for insurance in your loan, right? So they don't do that within that time period. Is that a big breach, right? And I say, all right, well, it's curable, right? We can fix it. Because at the end of the day, if you end up in court over something like that, it might not go how you anticipated.
Well, we were talking earlier, that's kind of like spending a couple $1,000s to go ahead and get a couple hundred back. And really you're at the same point then that you were in the very beginning, right?
And you may be actually worse off because you might have to pay the other side's attorney fees. And those are not cheap, let me tell you.
Coming from a lawyer. So.
Yes. Right. Now, what about you? You've had some issues too.
Yeah, I've had a couple of issues. One of the recent ones was we just had an appraisal done on a property, and somehow, some way, the VA appraiser went inside there and didn't notify everybody about what was going on. And the seller's agent didn't know. I didn't know, the lender didn't know, and then we tracked it down, and, the appraiser said, well, we tried calling the listing agent, but we couldn't get a hold of him. We got access to the property, so we just went in. It's probably not the most ethical thing to do. It's probably not the way that you want to conduct business, but like you're speaking about, at the end of the day, is it really worth canceling an entire contract over? And really, there was nothing I could do about it, nothing the lender could do, nothing you could do, nothing the other agent could do. Somebody just did something they weren't supposed to do, and, everything else is fine. We're closing in a couple of weeks. So sometimes those things work themselves out, but there's some really major things that you were telling me that don't work out, right?
Right. So say that there are title issues. Because under the contract, remember, the seller has to deliver marketable and insurable title.
Absolutely,
So if the seller is not working to resolve those issues, they can't come to court. And there actually was a Supreme Court of Virginia case where this did happen. There was a title issue. It had to do, I think, with, it was either adverse possession or transfer, some type of transfer that was an issue, right? And so the seller sued the buyer and said, the buyer needs to perform and owes me all this money, and here you go, I did what I was supposed to do. And then of course the buyer presented their evidence, and the court said, well, wait, not so fast, Mr. Seller, right? You have a duty and an obligation to fix title. Right, you have to do that before you can sell the property, right? And then if you don't, then you are in breach.
So what happened?
Well, the buyer won, got some money, so and then the seller was out of luck. They, So I've actually had some sellers ghost, and I use that term, ghost. That's such a common. But, they're working with you, and then all of a sudden they just vanish off the face of the earth. They're not responsive to your phone calls or your emails, and it's a title issue, right? And so then I have to go back to the buyer and say, I'm really sorry, the seller is just not, working with us. I'm not sure what happened. So that's a big breach. Another big breach is the buyer not showing up to sign the settlement documents and bring the funds. Right?
Not they're my buyers, they're showing up, I promise you.
Now, and I don't see it often, although I say this and then suddenly something happens.
I'm sure about that'll be the case, right?
It'll happen. But so that's a big breach. If the buyer doesn't show up to to sign the loan docs and all the settlement papers, and they don't bring their money back.
Right.
That's a big breach. So, there's big breaches and then there's smaller.
I guess the moral of the story would be, make sure, first of all, that you read the contract and understand
Sure.
it. And look, most people are not lawyers, but
Right.
they know lawyers, right?
Yeah.
And we recommend that if they don't understand something, they contact somebody. You can talk to your agent.
Right.
You can do a number of different things, but you have to make sure that you understand what's inside the contract,
Yes.
what your responsibilities are, what you're required to deliver,
Right.
and what the consequences could be
Right.
if for some reason it doesn't happen.
Exactly.
Right?
Yep.
Is that fair enough to say?
That's fair, yeah.
All right,
Because it's a legally binding document.
Okay.
Which it does say, please read carefully.
Yeah, of course it does. Yeah. So the moral of the story is, make sure you read the contract, make sure you understand it, and if you don't, ask a couple of people that might be able to help you out.
Yep.
This is Jim Trouts from eXp Realty.
Karen Daly from Ekko Title in Loudon, Ashburn.
And thank you for your time, and we'll see you next time.
Bye.
Bye.